Hello everybody and welcome to this enormously important webinar on something I think is really critical to the management of your properties, and that is property inspections. And I'm delighted to welcome back Dave Princep, who's helped us with a number of other aspects. Welcome, Dave.
Welcome. Thank you very much for inviting me back.
Dave's going to go through the slides and talk about it.
Hi, well, welcome to this seminar discussing periodic inspections. As Tessa said, it's a very important area and often overlooked. There's quite a bit of law that affects inspections and reasons why you need to inspect a property. Civil action can be taken by the tenant under several pieces of legislation. There's the Landlord and Tenants Act 1985. This deals with disrepair, and until recently was a very important piece of legislation used often by tenants as counterclaims for rent arrears. But basically this act puts an onus on landlords to maintain their property in repair, and it's only repair. Defective Premises Act 1972 is again only dealing with repair, but unlike the Landlord and Tenants Act section 11, where notice had to be given to the landlord, i.e. the landlord had to be informed that there was an issue there before they were liable. The Defective Premises Act basically put a duty on landlords to maintain their property in good repair. And it was this piece of legislation which really drives, or used to drive until the next piece of legislation, the need for periodic inspections, because unless you go to the property, you're really opening yourself up to civil action by the tenant and also obviously by local authorities. The piece of legislation which is very significant now is Homes Unfit for Habitation Act 2018, which basically brings both repair and hazards together and places a duty on all landlords to maintain their properties fit for human habitation. And it is these three pieces of legislation, certainly for civil action by the tenant, which are the drivers for periodic inspections. There's obviously a plethora of legislation, Housing Acts, property licensing, HMO regulations, etc., which can be enforced by the enforcing authorities against a landlord. And again, it's important that you check that your property does comply with the legislation at the beginning of the tenancy and throughout the tenancy. Otherwise, you may have enforcement action. You may be prosecuted or have a civil or a fixed penalty fine against you. There are implied terms about right to access for repair in the Landlord and Tenants Act, both for Section 11 and the new section dealing with unfit for habitation, and also in the Housing Act 1988. There's quite a bit of a legislation affecting the landlord's right of access. It's not a power of access, it's just a right. Do be aware, and I know a lot of landlords, particularly of bedsit HMOs, where there's an issue sometimes about going into what they call the common parts, and these are the parts which are shared by all of the tenants. The tenants of the bedsits cannot refuse the landlord, cannot legally refuse landlord access to the common parts. And it's important for HMO landlords who have bedsit properties that they're aware that there's a legal duty on them to maintain all of the facilities in the common parts. That's stairs, landing, bathrooms, kitchens, communal areas in a good condition. So it is very important that HMO landlords of bedsit properties inspect those. A HMO can also be a shared house, but because there are no common parts in a shared house, you do not have a power of entry. You do not have the permission without the tenants allowing you to go in there. You do not have permission by law to go into the shared accommodation if it's a joint tenancy. So that's a background, a bit of background about the legislation.
Perhaps it might be worth mentioning briefly, Dave, that new regulations were laid before Parliament yesterday um, on the new electrical regulations that are going to be coming out. People who receive the bulletin, which is probably everybody listening to this, I did mention this in the weekly bulletin, and I gave you some links to some articles, one on the Landlord Law blog and one on the Nearly Legal blog about the regulations, but be aware that these are coming. So that's important.
Yeah.
We've got a question for Bianca, who says, please explain what is meant by written confirmation under the 85 Act.
Oh, basically written confirmation. This is basically that the landlord must have been notified in writing that there is some disrepair at the property. And normally what will happen in a situation where the tenant proposes to take legal action against the landlord is they will get a letter listing all of the items of disrepair which they need attention, and so that would be the written confirmation to the landlord. But do be aware that it doesn't have to necessarily have come just from the tenant. If the landlord has had a valuation of the property or has had an inspection by a local authority, and the valuation report or the letter from the local authority details what is needed, then that basically would be the written confirmation and would technically allow the tenant to take action against the landlord for any items of disrepair.
Yeah, I mean, I think that if the landlords get an oral notification, they are supposed to do something about it. But if the tenants actually want to bring proceedings in court, then the pre-action protocol for disrepair claims will come into force, and that's when they've got to have the written confirmation. Otherwise, the judge may not allow the claim to proceed until they've done that, I think. Is that right, Dave?
Yes, that's right. Yeah, I think that whenever a tenant complains to you by whatever means, obviously act upon it. Confirm that you received the complaint and obviously take steps to deal with it. One of the problems which landlords sometimes have is also vexatious tenants who complain repeatedly about the same issue. And there you have to take a pragmatic approach to it, but certainly don't completely ignore it. If a tenant is complaining to you every month about condensation, do go round the first few times. But if you've been there 4 or 5 weeks before about condensation, you know, say we know that you've complained and it's unlikely that it's got any worse, and therefore we don't think that it's actionable on our part, and obviously give them advice on the sort of things that they can do to try and reduce the condensation. But do take some action. Do obviously acknowledge that you received the complaint, and certainly some landlords do actually have a pro forma which the tenant is requested to actually complete and send to them, so that everybody is aware of the issues that are relevant. Because one of the problems is the tenant will complain about a missing window or a window that won't open, and you go there with the intention of dealing with that issue, and then suddenly they come up with a lot of other issues which they hadn't mentioned to you before. So if you can get it in writing, ideally from them, then certainly that will help you. But if they do phone you up, then just drop them a line to say, well, okay, I'll come round as agreed on these dates to deal with the issues you mentioned, which was X, Y, Z.
I think it's important generally that I mean, I remember you said in one of our earlier talks, David, great comment, that one of the most important things about being a landlord is you have a briefcase full of paperwork. And I think that's so true. You've got to have a paper trail. You've got to have a record of absolutely everything you do. So you've got to do telephone attendance notes. You've got to do notes when you go around. You've got to do notes of absolutely everything. Some of the letting agents listening to this will probably have signed up to a quite good system called FixFlow, which is where records are kept automatically and tenants notify you through an online platform. I'm not sure whether there are any of those for landlords at the moment, but that sort of thing is quite good as well.
Yeah, I think just keep records of things. It is It seems very time consuming and bureaucratic when no problem arises. But if a problem does arise,
You'll be
and
grateful you did it.
you'll be very grateful that you've done it and you've got a record of exactly when and what action was taken. Yeah.
Yeah, I mean we've got a video on the site which is actually quite an old one, which is Martin Ashley Taylor talking about hearings for possession, particularly relating to rent arrears, and he talks there about what you have to do if the tenants come up with potential defences, and he talks there about how important it is that you've got the paperwork ready there to hand to him so he can deal with it instantly. So keeping proper records is really important. Shall I move on, Dave?
Yes, next slide. Yeah, thank you. Okay, the advantage